Welcome, I'm the loud little ducky. We are going to continue going over filings in the Owens v. Marraccini case for the renewal of the DVRO, even though Gingras has sidetracked this whole thing and is making it about himself instead of the actual case. So these are going to be the declarations of Omar Serrato, Michael and Rachel Juarez, lawyers of Mike Marraccini, and talking about their interactions with Gingras with this case, as well as some papers that I missed out of the last filing, which aren't really that important, but we're going to put them in here so that we have all the context in the filings. So let's get quacking. So here we have, this is a request for a temporary emergency ex parte order. He marks other. Motion to shorten time for David Gingras' motion to intervene and respondent's motion to disqualify David Gingras. 2, Laura Owens, who is the respondent of this. Other orders. Respondent Mike Marraccini by and through undersigned counsel pursuant to California Rules of Court Rules 3.1200 through 3.1207 and California Code of Civil Procedure 128A3, and hereby respectfully submits the statement in support of ex parte application to shorten time for hearing on if David Gingras' motion to intervene for the motion to strike and sanctions and disciplinary referral, opposition to the motion from respondent is attached. 2, respondent's motion to disqualify David Gingras. For those codes, the motion is not expected to be opposed. Respondent requests ruling on these matters on the pleadings, something that the courts see both motions for hearing on the date of ex parte Tuesday, October 2nd, 2025. Something available date or at the earliest date before the DVRO evidentiary hearing, and that the court order shortened time for any opposition as the court deems appropriate, so that these issues are fully resolved in advance. Okay, sorry. It's really small and weird to read in this thing, so try to read it. Sorry that was so slow, but that's what he's requesting. And then there's this one, other motion to shorten time for pending motion. So that's the request for the order. Nothing on the first page on this one. Second page is other orders requested, order shortening time for David Gingras' motion to intervene, and other request and respondent's motion to disqualify Gingras. And then we go down to facts to support is please see attached Omar Serrato's declaration attached that supports both opposition to David Gingras' motion and an order shortening time. And this was signed on September 30th, 2025. So this is something that they requested. Gingras wrote a blog yesterday, and he was like, oh, Omar lost, I won. No, not necessarily. I mean, he didn't decide on the merits then, but he's going to give the parties like a week, which is still like 12 days in advance, which Omar just wants them to be figured out before the 21st so that this is not all jumbled together with what the case is actually about, a DVRO renewal. It's not about attorneys' feelings. Here is attachment 7. Respondent Michael Marraccini, by and through undersigned counsel, pursuant to California rules, Rule 3.1200 through 3.1207 and the California Code of Civil Procedure 128A3, and hereby respectfully submits the statement in support of ex parte application to shorten time for a hearing on. So I could have just read this part instead of like doing me looking like I don't know how to read earlier. All right. One, intervener David Gingras' motion to intervene and related requests to strike for sanctions and for a disciplinary referral. Opposition to this motion from respondent is attached. 2, respondent's motion to disqualify David S. Gingras, California Code Civil Procedure 128, California Rules of Court, Rule 3.1202. This motion is not expected to be opposed. Yeah, it's not supposed to be opposed because Gingras isn't supposed to be representing her. So if he's not going to represent her, why would there be opposition? Yeah, Gingras isn't going to be on this case. Okay, you agree to that? All right, I'm going to sign to disqualify him. Easy peasy. Gingras is making it ridiculous and just wasting time and Marraccini's money, which is what he wants to do. He wants to make everything a circus when it just needs to be decided on its merits. Requested relief. Respondent requests ruling on these matters on the pleadings or an alternative that the court special set both motions for hearing on the date of the ex parte, Thursday, October 2nd, 2025, or the earliest available date before the DVRO evidentiary hearing, and that the court orders shortened time for any opposition/reply as the court deems appropriate so that these collateral issues are fully resolved in advance, which they're going to be resolved in advance. So I don't know where Gingras thinks that he got a win, but whatever. He lives in his own little world that's not reality. This application is supported by the declaration of Omar Serrato, which provides a factual showing of the need for expedited consideration. California Rules Court, Rule 3.1202. Also attached is respondent's opposition to David Gingras' motion to intervene, request to strike, sanctions, and for disciplinary referral. There are no additional briefings required for an adjudication of either motion. Therefore, hearing on the matters is requested on the date of the ex parte, presently request for Friday, October 2nd, 2025. Now it's going to be on October 10th, 2025, which is next Friday. Okay, points and authorities. Good cause to grant this motion is as follows. Gingras is a percipient witness to dispute events and has personal disciplinary exposure arise from the same facts, creating Rule 3.7/1.7 issues. If his role remains unresolved, he has improperly filed a motion to intervene and for other relief in a way that serves to enlarge the issues of the underlying DVRO. Yeah, this is not the time or the place, as we've said. 2. On September 12, 2025, Mr. Gingras identified himself as an intervener, filed a procedurally defective, as outlined in respondent's attached opposition to Gingras' motion to intervene, along with the procedurally defective request to strike the motion to disqualify, impose sanctions under CCP 128.5, and refer respondent's counsel to the State Bar for disciplinary action. These filings introduce collateral attorney-focused disputes that risk derailing trial preparation and delaying the DVRO hearing. Addressing these threshold matters now promotes judicial economy and prevents avoidable continuances. Mr. Gingras' filing enlarges the case with collateral attorney-focused disputes, intervention, strike, sanctions, and disciplinary referral that should be resolved before the evidentiary hearing so trial preparation is not derailed. 4. Prompt resolution is necessary to avoid last-minute disruption of the DVRO renewal hearing and to preserve the integrity of the proceedings. The underlying case concerns a domestic violence restraining order, DVRO, between petitioner Laura Owens and respondent Michael Marraccini. The DVRO was initially used in 2018, renewed in 2020, and is now the subject of renewal requests by petitioner to make the order permanent. 5. Respondent further advises the court that the motion to disqualify Mr. Gingras is expected to be unopposed, given Mr. Gingras's current intervention posture. Accordingly, respondent seeks the earliest available hearing date on both motions. This application is supported by the Declaration of Omar Serrato, which provides a factual showing of the need for expedited consideration, California Rules of Court, Rule 3.1 or 1202. Wherefore, respondent respectfully requests that this court either rule on the matters on the pleadings or special set the hearing on 1. Gingras' motion to intervene and related strike sanctions disciplinary request, and 2. Respondent's motion to disqualify on the earliest possible date before the DVRO evidentiary hearing. That order was granted. That is what Omar asked for. 2. Order shorten time for opposition and relies so these collateral issues are decided in advance of the DVRO evidentiary hearing. Okay, so now we're getting into the Declaration of Omar Serrato in support of ex parte applications seeking to shorten time for David Gingras' motion to intervene and respondent's motion to disqualify David Gingras. And so he says, I declare I'm an attorney licensed in California and counsel of record for Michael Marraccini in this DVR renewal proceeding. I have personal knowledge of the facts stated below and could competently testify to them if called. 2. This declaration provides the factual showing of good cause and the need for expedited relief in support of respondent's ex parte application for order shortening time to hear A. Intervenor David S. Gingras' motion to intervene and related strike sanctions disciplinary referral requests, and B. Respondent's motion to disqualify Mr. Gingras. C. California Rules 3.1200 to 3.1207 ex parte requirements. 3.1202C, declaration showing irreparable harm, immediate danger, or other statutory basis. Then 3.1300B, court may prescribe shorter times. And 1005B, notice may be shortened by court. 128A3, court's inherent authority to control proceedings. All right. Then we have the motions are ready to be heard without additional briefing, and the disqualification motion is not expected to be opposed. Respondent's opposition to David Gingras' motion are included in this filing. The underlying case is petitioner Laura Owens' application to renew a DVRO first issued in 2018, renewed in 2020 through July 10, 2025, and now sought to be made permanent. Respondent requested and the court set a multi-day evidentiary hearing. 5. Attorney David S. Gingras is a percipient witness to disputed facts central to the renewal, including the June 10, 2024 Arizona courthouse incident. By his own descriptions, he contacted law enforcement about respondent on the date. Respondent contends that the contact was improper and a bar investigation is pending. These circumstances raise Rule 3.7, lawyer witness, and Rule 1.7, current client, conflict concerns that directly threaten the integrity of the evidentiary hearing if unresolved. Number 6, September 12, 2025, intervenor, filings and collateral disputes. On September 12, 2025, Mr. Gingras, styling himself as an intervenor, quote unquote, filed papers seeking to intervene to strike respondent's disqualification motion to impose sanctions under Code Civil Procedure 128.5 and to obtain a disciplinary referral against me. These filings inject attorney-focused collateral disputes that risk derailing trial preparation and delaying the DVRO hearing, which is what I said. He is derailing this thing. I did not receive a 21-day safe harbor service of any 128.5 or 128.7 sanctions motion before those papers were filed, which Gingras does explain in the motion that was attached or separate from his declaration that we read. So we will go and hear why Gingras says he doesn't need to give a notice, because he does say why he doesn't need to do it, which Omar even mentioned in his other motion, or his opposition to his motion, about, I don't care what Gingras says, it's proper to give notice. But we'll see what Gingras has to say, because why? We cover both sides. Cover both sides. These are not my words. These are what Omar wrote, and it is in a court filing, a public court filing. That's why we read it. There is a good cause to shorten time so that these threshold issues, intervention, strike, sanctions, disciplinary referral, and disqualification, can be decided before the DVRO evidentiary hearing, as Gingras' motion are procedurally defective, and the motion to disqualify David Gingras by Gingras' account will be unopposed. The hearings are currently scheduled for the same dates as long as the long cause trial of October 21st, 2025. They enlarge the case with collateral attorney-centric disputes and will otherwise upend trial preparation. Deciding them now promotes judicial economy and prevents avoidable continuances. Mr. Gingras is a witness with personal disciplinary exposure on the same facts, allowing his role to remain unresolved risks, Rule 3.7 and 1.7, complications during the evidentiary hearing itself. No additional briefing is necessary to decide either motion. Respondent's opposition to intervention is already prepared, and this disqualification motion is not expected to be opposed. Shortened time, therefore, will not prejudice any party and will conserve judicial resources, which the court likes to save money and time. The court loves that. 8. Respondent requests rule on these matters on the pleadings, or in the alternative that the court's special set both motions for a hearing on the date of the ex parte, Thursday, October 2nd, 2025, or the earliest available date before the DVRO evidentiary hearing, and that the court order shortened time for any opposition/reply as the court deems appropriate, so these collateral issues are fully resolved in advance. I think, based on what happened, and that there's going to be a week given, I think that was granted. 9. Immediate resolution of Mr. Gingras' attempt, intervention, and his collateral requests, together with respondent's disqualification motion, will preserve the integrity of the DVRO evidentiary hearing, avoid last-minute disruptions, and promote efficient case management consistent with the court's authority under Code Civil Procedure 128A3 and California Rules of Court 3.1300B and 3.1202C. I declare under penalty of perjury under the laws of the state of California that the foregoing is true and correct, executed on September 30th, 2025 in San Bernardino, California, dated September 30th, 2025. Respectfully submitted, Omar Serrato. So that is Omar's declaration. Let's go to the next declaration. This is the declaration of Rachel Juarez in support of opposition to David Gingras' motion to intervene, strike, sanctions, and motion for disciplinary referral to the state bar. Our hot bench queen. Yes, Miss Rachel Juarez. Let's hear what she has to say, because we know She likes to deliver the facts and the law appropriately, which Gingras is not able to do. She says, I, Rachel Juarez, declare I am an attorney licensed to practice law in California. I am not counsel of record in this matter. In August 2025, I consulted with Respondent's Counsel, Omar Serrato, on attorney ethics and case management issues related to his representation of Mike Marraccini in connection with Petitioner Laura Owen's DVRO renewal. I presently intend to associate into the case on behalf of Mr. Marraccini so that I can assist Mr. Serrato as co-counsel for the upcoming trial. I make this declaration based on my personal knowledge. 2. I participated in a 3-way telephone call with attorneys David Gingras and Omar Serrato. According to the records from the cell phone carrier, the call lasted approximately 66 minutes. The 66-minute call, as Gingras said. I have carrier logs reflecting both the date and the duration of the call. Bring in the receipts. My understanding of the purpose of the call was that it was to discuss this case and specifically its possible resolution. I anticipated the call to last considerably less than 30 minutes. So she is saying about 30 minutes at the absolute most. Probably even shorter, but they were on the phone for longer than an hour because Gingras doesn't know how to shut up. From the outset of our discussion, Mr. Gingras was speaking rapidly, bouncing quickly from topic to topic. It was often difficult to keep Mr. Gingras focused on matters related to this case, and he often steered our discussion towards a series of legal/personal issues that Mr. Gingras himself was going through at the time, and which he was eager to explain to us. He's like, do you know what I'm going through? I don't need this case. This is why I'm not representing Owens. I have this, and this. And this is why I drink myself to sleep. Okay. Anyways. Among those issues was the Arizona State Bar investigation into alleged misconduct on the part of Mr. Gingras involving Mr. Marraccini, specifically an incident on June 10, 2024 in and around an Arizona courthouse. The other personal issues we discussed are not implicated by these proceedings, and I will therefore forego any detailed discussion of them. I wish you would have spilled the tea, but you're a professional, so I'll let it go. I do, however, remember the sum and substance of such topics and would be competent to testify about them if asked to do so. So, Judge, if you want me to tell you all the juicy gossip, I will. 5. At some point during the phone call, we ended up discussing a concern Mr. Serrato and I had been having, the fact that Mr. Gingras was a precipient witness to disputed events underlying Miss Owen's renewal request. Based on my review of the file in this matter, Mr. Gingras is a necessary witness with respect to the disputed events of June 10, 2024, incident that Miss Owens raises in her request for a renewal. This is, of course, the same June 10, 2024 incident in Arizona referenced above that Mr. Gingras said was presently the subject of the Arizona State Bar investigation, which explains his status as a precipient witness. We briefly discussed with Mr. Gingras' role as a precipient witness to the June 10, 2024 incident would constitute a conflict of interest in this matter. Yes, it would. As the conversation continued, Mr. Gingras became increasingly distracted and was bouncing from topic to topic, resulting in the discussion that was moving rapidly between the case and Mr. Gingras' personal issues, one of which, as explained above, is the Arizona State Bar investigation into Mr. Gingras that involves Mr. Marraccini. Every few minutes, Mr. Serrato or I gently attempted to bring the discussion back to potential resolution of this matter. that would require the parties to go to a contested hearing. 7. As is a typical in settlement discussions, Mr. Serrato and I explained to Mr. Gingras, both generically and specifically, why we do not believe a live testimony hearing would benefit either party in this matter. Specifically, we discussed why we did not believe a trial would benefit Miss Owens. Yeah, it wouldn't. It hasn't really gone her way. Number 8. At some point during our discussion of disadvantages to the parties of going to trial, Mr. Gingras interjected that it would, in fact, be to his personal benefit for this matter to reach a point where Mr. Marraccini would provide testimony in this case, as opposed to this matter reaching conclusion without Mr. Marraccini or Miss Owens providing live testimony. Mr. Gingras was speaking very quickly and in a somewhat disjointed manner went to explain that he believed it would be helpful to his defense of the pending Arizona State Bar matter for his renewal request to proceed at least up to the point where Mr. Marraccini would provide testimony. Okay, let me. Let's see, he was disjointed, so he was probably drunk or on something, in my opinion. Yeah, so no, you can't use this case as something to be beneficial to your Arizona bar complaints. Like, no, that's not what this is. Okay, 9. To the best of my recollection, Mr. Serrato and I both interjected at that point, in fact, interrupting each other, as we attempted to point out that Mr. Gingras' personal interest in how this matter is resolved is a potential conflict of interest. I specifically recall believing and saying that this situation constituted the definition of conflict of interest. Yeah, because conflict of interest doesn't mean that your views don't align. That's not what this means. Like, when, let's say a doctor, okay? A doctor's wife comes in, or a doctor's child comes in. It is a conflict of interest for that doctor to work on his wife, like for a surgery or something, or his child. Because it's not because they don't have the same beliefs and views. Because obviously their beliefs and view are going to want to align. They all want each other to stay alive and have the best care possible and be a happy family again, right? But you're too close to it. And so if you are too close to it and your decisions can decide to go a different way, maybe you do something that you would normally do in order to further what you want done, that could actually be a problem. That's where the conflict of interest come in. It doesn't have to do with the fact that Gingras and Owens' beliefs aren't the same and they want the same outcome, because they are aligned in that. But that is not what this means. He thinks it means that, apparently, but no, that's not how it is at all. Mr. Gingras immediately and forcefully disagreed that the conflict existed. He and stated in substance that there was no conflict of interest because his interests were the same as aligned with Miss Owens' interest. He insisted many times that his conduct had been lawful and appropriate. And I can say that there are Volkswagens on Mars. It doesn't mean it's true. 11. My understanding at the time of the call was that Mr. Gingras was counsel of record for Miss Owens in this matter. At no time during the call did Mr. Gingras say that he had already withdrawn from representing Miss Owens. Because remember, he says that, he says that he submitted a notice to be counsel, but it got rejected on a technicality. So that's why he's like, well, I don't think I should have to withdraw. But in his world, he was representing Owens at that time. He represented her at that hearing. So why would anybody think that he was not her attorney? It was common sense to think that way. Mr. Gingras also did not definitively say he would withdraw. As explained above, Mr. Gingras was not an easy to understand during portions of the phone call. His speech was disjointed and often difficult to follow, and at times he would speak in long monologues. He took all matters of positions and often discussed them with himself. Sir Bart, you are not supposed to be having conversations with yourself in front of people. Talk to yourself in private. That's what sane people do. However, the one thing Mr. Gingras steadfastly maintained was that he had no conflict of interest in this matter and that he had not acted inappropriately or unethically. Very little was clear by the time the call ended. Yeah, because maybe up to that point he hadn't done anything. He has now done some things in this case. Maybe up to that point, in August 15th, I believe, he hadn't done anything inappropriate or unlawful in this DVRO renewal case. As of today, he has lied to the court, at minimum. More on that later. Okay. However, I left the call convinced that a motion to disqualify was absolutely necessary, given the enormity of the conflict of interest at play, and Mr. Gingras's absolute denial that any conflict of interest existed. Given the potential of a serious prejudice to Mr. Marraccini, were Mr. Gingras to not withdraw or withdraw but then substitute back into the case, and the relative speed of the DVRO matters. I believed it was necessary for Mr. Serrato to get a motion to disqualify on file with the court. And I agree. Number 12. Though it often delved into personal topics, the call was professional on all sides. At no point did I or Mr. Serrato threaten, coerce, or attempt to intimidate Mr. Gingras in any way. The discussion as it related to this matter focused on potential resolutions of this matter, case management, and avoiding collateral disputes. After the call, I learned that Mr. Serrato sought written confirmation of Mr. Gingras' status as counsel in this matter, and that Mr. Gingras later indicated in writing he did not intend to continue representing Miss Owens. If helpful, I can authenticate the follow-up emails as exhibits RJ2. I did not and do not believe that such writing obviated the need for a motion to disqualify. Indeed, due to the erratic nature of the prior conversation with Mr. Gingras' steadfast insistence that there was no conflict of interest in this matter, my review of public documents, including the pleadings and communications between Mr. Gingras and opposing counsel in other cases, and the nature of my own past experiences with Mr. Gingras, I believe I would have left Mr. Marraccini at risk for his counsel to forego obtaining a ruling that Mr. Gingras' personal interest in this case, as it relates to ongoing Arizona State Bar investigation into his conduct, constitutes a conflict of interest in his representation of Miss Owens to this matter. I declare under penalty of perjury, under the laws of the state of California, that the foregoing is true and correct. Executed on September 30th, 2025 at Los Angeles, California. Respectfully submitted, Rachel Juarez. Okay, so that is hers. And she was professional. And she still gave us a little hint that, hey, yeah, he was probably drunk. So, then we have some attachments that have gone with these things. With Omar's opposition and these declarations and everything, these are some of the attachments. So this was a blog that Gingras posted on September 18th, 2025 that says, I can understand how his motion to disqualify you didn't go over well. That can be a hit to the ego of any guy, but it's for content fodder. Why are you contributing to it? Lots of people say you are creating online shit show to be in a Netflix documentary. Is this true? Is this true? So he is answering this. And in this post, he basically is like, nope, I don't want fame. You know, I am not desperate to get a documentary. Sir, you went on Dr. Phil. You've apparently been on A&E. Like, give me a break. You took a case that was about The Bachelor, you know, going up against The Bachelor because winning against The Bachelor would be good for your image. Another case that you wanted in on was the Cody Wilson case because it was making headlines. So do not say you are not out for fame because it's a lie. Also, he brags about being an attorney listed on paper for Colin Farrell at one point. So, like, what does this say? There was a time before online P, and there was a time when nude pics and, God forbid, videos of celebrities were almost impossible to find, like unicorns. Then this, and this. Okay. Internet like, yeah, okay. Don't act like you're not trying to get fame. It's just not working for you because you're a douchebag. Then here's more of his blogs. This is a court filing, a public court filing, where these are admitted as exhibits. These court filings are not publicly owned by you, David. Okay? Definitely, A&E's content is not owned by you. All right. Just so we are clear. But you don't want fame, right? September 12th, 2025. TGIF and just stop. The tea is brewing. Go touch grass. And so he's like, I follow my schedule, not yours. I'm not going to share anything online. No, I'm not posting pleadings. But he ended up posting them later. So he says, I may regret this. I reserve the right to immediately turn comments off for abuse. But for now, I will leave them open. Also, I will post short comment to confirm that my filing is submitted, but again, I will not be sharing it. Pleadings have been filed and served, he said. So he's posting stuff about this case while it's ongoing. Do you know what Omar has done? No postings about this case. He has said nothing about the Owens any case. Owens v. Eckerd, Owens v. Marraccini, none of it. Since he took on Marraccini as a client. And David also made YouTube videos and blogged and everything else about Owens' case when he was in the middle of the case. He says it's with his client's permission, but I'm not so sure that she wasn't gaslit into saying that this would be good for her. But she takes David's advice. Jan and Ron seem to think David's advice is gold. Sadly, they have been misled. Yeah, and he turned off the comments because I didn't even think, I wish I would have, but I didn't even think to go look at the comments on his blog about me and Omar. Or if he just turned them off automatically, but they're turned off currently. So it goes through here, and he's going to be in the comments section. Somebody's calling him out for, possibly turning comments off, Okay. Then David writes this. 2 things. I want to fight Omar in court. Well, that's not 100% accurate. I would prefer not to be involved in this light at all, but Omar gave me no choice. Still, the battle will be fought in court, not online. Okay. While you continue typing away in your blog. 2, the question, in that hearing, did you tell the judge that you just found out about Laura's criminal charges? As a general rule, I would never lie to a judge. I sometimes misspeak unintentionally, like everyone else, but I have no idea what you're talking about. The Zoom hearing lasted a matter of minutes. My only significant comment to the judge was that I told the judge that I just found out about Laura's charges. I do not believe I told the judge that I just found out about them. Obviously, that wouldn't be correct, so I'd have no reason to say something like that. Yeah, but you might have not been in your right mind either. Especially in a recorded hearing. All I can say is no, I have zero recollection. You have lots of missing memories due to drinking. P.S. I have been doing this stuff for 25 years. Stop saying you've been doing this for so long. Good for you. Sadly, I think a first year out of law school person could beat you in court. But that's just, actually a pro se litigant could probably beat you in court, but that's my opinion. Let's see. There has never been a single proven instance of me lying in court, ever. I would guess that over the years, a handful of folks have accused me of being non-truthful in some way, but every single one of them was wrong. I do not lie, ever. You do a lot of speculating. And you speculate in order to try not to make it a lie. Okay. What's example? I mentioned a cheerleader case many times. Contention, misrepresentations in law. However, defendant's characterization things denied the rules. Yeah, he a lot of times scoots across the line, but this may be where he is going to be caught lying. Where does the leave? The petitioner appears the petitioner doesn't have a lawyer. Go. So these are comments that were on the blog. It says, I appreciate questions. I would like to respond, but I don't see any value in public debate. Then why are you writing this shit? You will see all my explanations when you see my motion. ultimately, the court may not accept my pleading. I'm not a party to the case, nor do I represent a party, which is the whole point of what I filed. Non-parties typically can't just file crap in any case they want. Yeah, well, you seem to think you can. All right, more comments that he talks about. Talking stuff about Omar and all that. If you want to read those, you can pause and read them, or go pull up the filing on victims of Laura Owens. She or he, I don't know what it is, what the person is over there that runs that, but they've got all these. Then he shows a tiny Tuesday update blog, shows that, those things are in process and all that. And then his next blog, we all have the right to remain silent, but can or should I? I don't think you have the ability to remain silent. That's just me. This is where he was talking about his birthday and that it's been a tough year and a horrible summer. People are trolls. And then posts pictures of things that he's been doing to his mom's house. Because somebody guessed that he was doing this. Because they wondered if he was actually in rehab. Because he did actually stay silent for a little bit, but not for long. Okay. Then here is a video for Dave Neal, and that he wrote a letter to Dave Neal, which he shouldn't be reaching out to Dave Neal. Dave Neal doesn't want to have anything to do with him, but he continues to write Dave Neal emails. And Dave Neal has gone over this letter. Megan Fox's posts some thoughts on the last two legal cases I've covered, What the Hells versus Preston, and Clayton Eckerd versus Laura Owens. Both bad lawyers who have entered the cases late after several YouTube channels had covered the issues in depth and had already come to a conclusion on who was right. These lawyers, David Gingras and Brucey Bruce, demanded that all of the coverage stop immediately or change to the favor of their clients who were demonstrably lying about many things. Both lawyers have tried to paint the YouTubers as opportunists and grifters who aren't deeply convicted of their positions, but instead primarily interested in money. We have all heard this before. Think Johnny Depp. They have both threatened lawsuits to stop free speech. They have both engaged in online behavior that can only be described as unprofessional and unbecoming of an officer of the court. Agreed, Megan Fox. Agreed. Megan Fox and her Muppet self. Then the complaint about me and Omar. Another day, another lie. I have gone over this. He talks about YouTube approved my copyright strike and removed Ducky's video. Justice for Dingus. Apparently, Ducky thinks breaking the law is cool when she does it, but not when anyone else does it. So she posted a short little video complaining about the strike. She will probably remove this, which is fine. I've made a backup. But here's her whining about what happened. Thank you for promoting my channel, sir. Thank you. And I went over his accusations in this blog because I wasn't I wasn't going to fully share it. Like, he copyright struck my channel. I did reach out to him. I wanted to give him a chance to make it right. He refuses, basically. He doesn't want to make it right. Because it's not about his image. Because he should be proud of his image that he posted. He was boasting about it on Twitter, his public Twitter page. And so I don't understand why he's throwing this big of a fit about somebody using a picture for 1 minute and 1 second in an almost 2-hour video. But here we are. The ducky got him. Yeah. The ducky hurt his fifis because I was reading court filings. Sir, if that hurts your ego, you need more help than we thought. Then he has his video that says, JFC YouTuber, loud little ducky, lies and blocks truth. No, I didn't. Not blocking truth. I was trying to give you a chance to be a decent human being. And then here's things, how many views that it got. Over the time. And then he posted, I recently submitted a copyright strike against a JFC, owned and used it in her thumbnail without my permission, which she claimed that she reached out to me, blah, 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 and his comments are turned off on this video. So, yep. That is what he is doing to me. Because I've offered to remove it. I've offered to remove his picture. You don't want the smoke? Move along. It's not a physical threat. It's just quote. It's just a saying. Can't handle smoke, get out the kitchen. Where there's smoke, there's fire. You don't want the smoke. It's just something people say when they're like, you don't want to start something with me. You know, you don't want the smoke of me beating you at your own game. Because it is not going to end well with the way you conduct yourself. We've got the facts and the receipts on our side. And you and your client in the Eckerd case are nothing but a bunch of chaos goblins. You want to go around and turn everything into a 3-ring circus. When all people want you to do is be a decent human being. Quit causing chaos everywhere. You want people to respect you as a lawyer? Act respectable. Respect is earned. It's not given. And you have not earned anybody's respect out here acting like this. So stop lying about, want the smoke. It has nothing to do with gun violence. You're the ones with guns in your videos talking about people. That you are in fear for your life. Over what? Some online people using words? Nobody's threatened you. But that is all I have for this video. I will be back shortly with more filings and more videos. So like, comment, subscribe, turn those notification bells on so you do not miss a video. And I will see you next time.